icon to record your questions. All questions will be taken at once at the end of this sessions by all the speakers. Having said that, at this point, I would like to invite the president of the chamber and chairman of council of NBCC, Mr. Kayode Falowo, for his opening remarks. Thank you.
Thank you very much, Taiwo. And may I please request that my video should be enabled? Okay, you've done that now. Thank you very much again, Taiwo, for the brief introduction. Patrons and council members of the Nigerian British Chamber of Commerce, distinguished ladies and gentlemen, I am indeed grateful to have all of you here with us today. And it is my pleasure to welcome you all to the webinar themed CAMA 2020 Reforms and Outlook, being organized by our chamber through one of our trade groups, the Professional Services Group, in collaboration with one of our respected members, Alex Law Firm. The creation of the Professional Services Group years ago was meant to develop a platform that addresses issues affecting members in the sector. I can say with joy that over the years, this group has achieved the objective for which it was set, and indeed has become one of the trailblazers amongst our trade groups. Evidence of that is in what we are experiencing today, which is the webinar that is being hosted in collaboration with Alex. On the 7th of August 2020, His Excellency President Muhammadu Buhari assented to the Companies and Allied Matters Act 2020, which repealed and replaces the Companies and Allied Matters Act 1990. CAMA 2020 provides a robust framework for reforming identified onerous, legal, regulatory, and administrative bottlenecks, which for 3 decades have made doing business in Nigeria substantially difficult, particularly for micro, small, and medium-scale enterprises. The Act introduces measures to ensure efficiency in the registration and regulation of corporate vehicles, reduce the compliance burden of small and medium enterprises, enhance transparency and stakeholders' engagement in corporates to ensure that we have a better business operating environment in Nigeria. The overhaul of the CAMA, which is the foundational legal basis for corporate vehicles regulation, is long overdue, as this is the first comprehensive update in 30 years. CAMA 2020 is undeniably a progressive development in the Nigerian business and economic landscape, and a big boost to the ease of doing business campaign of the federal government of Nigeria. It is against this background that we organize today's webinar. And we have put together, for your pleasure and listening, a panel of experts who will highlight the benefits of the CAMA 2020, especially to micro, small, and medium-scale enterprises, and discuss the impact on businesses and ease of doing business, to mention a few. We have with us today Mr. Theophilus Emua, and we welcome you, Mr. Emua, who is the managing partner of Alex, where he heads the firm's taxation intellectual property, corporate and commercial, and company secretarial practice groups. He is widely acknowledged as one of Nigeria's leading lights in tax practitioner. He is a fellow of the Chartered Institute of Taxation of Nigeria and was the vice chair of the Tax Law Review Committee of the Institute. I had the pleasure many years ago of being on a panel with Mr. Emuwa in the London Stock Exchange, where he gave a very good account of himself and his law practice. And he also helped to sell Nigeria in terms of the ease of doing business. So we're quite delighted, Mr. Emuwa, to have the benefit of your very rich experience with us today. Mr. Emuwa has provided advice on privatization options and strategies for clients and has reviewed business processes and procedures for operating in the petroleum sector. He has also led several due diligence reviews and advised on environmental matters and compensation issues affecting an oil spill. Our second speaker is the man that has been at the center of all this, and he is Alhaji Garba Abubakar, Registrar General, CEO of the Corporate Affairs Commission. Before his appointment, Alhaji Garba was the director in charge of compliance and litigation at the CAC. He had earlier served as the special advisor to the former Registrar General between 2010 and 2017. In that position, Alhaji Garba championed the reforms on the ease of doing business, particularly in the areas of electronic registration, consolidation of registration forms, integration of the CAC registration portal with the FIRS stamp duty portal, as well as the creation of public search window, which provides free information to the public on all entities registered by the CAC. There's no doubt in my mind, and I believe in yours also, that this is a case of a round peg in a round hole, or a square peg in a square figure. He's done extremely well, and the experience that he had gathered over time was displayed very quickly when we had the commencement of COVID-19. You could see that the CAC was able to pivot very, very, very rapidly and to develop new ways of ensuring that activities in companies went unhindered, even while awaiting changes in regulation and the legal environment. Thank you very much, Registrar General, for the good work you are doing for our dear nation.
Thank you, sir.
Our third speaker is a prominent speaker and a thought leader on tax, business, governance, and economic matters. He is a member of the Ministerial Committee on the implementation of Nigeria's tax policy and was a member of the Working Group on Voluntary Assets and Income Declaration Scheme. He's a contributor to the annual Doing Business report of the World Bank, the research director for the Fiscal Policy Roundtable of the Nigerian Economic Summit Group, NESG. He's a member of the ACCA Global Governing Council and chairman of the ICANN Taxation and Fiscal Policy Faculty Board. He's Mr. Taiwo Oyedele, Fiscal Policy Partner and West Africa Tax Leader at the NBCC. Director of DCSL Corporate Services Limited, and our own very dear Deputy President at the NBCC. Mrs. Adeyemi is a member of the International Bar Association. She is well-versed in litigation, corporate and commercial law practice, and has worked on various assignments spanning corporate restructuring, mergers and acquisition, foreign investment regulatory procedures, due diligence procedures, prior to mergers and acquisitions and stock exchange listings. I am certain that these industry leaders and experts will provide us with the relevant information and share the key changes and innovations in the Act that are relevant to the Nigerian business community and how this will affect the general ease of doing business in Nigeria. I wish to specially recognize the patrons and council members of NBCC who have joined us at today's webinar. I also thank members of our secretariat and indeed the professional services group for organizing this webinar. As some of you may be aware, the NBCC is a bilateral organization whose main objective is to foster trade and investment relations between Nigeria and the UK. It is over 43 years old now and currently has over 350 top corporate organizations in Nigeria and the UK as its members. The NBCC is an affiliate of the British Chambers of Commerce, which gives our members access to a network of 53 chambers across the UK and 49 other affiliates worldwide. Let me use the opportunity to invite those of you who are yet to join the NBCC to please do so. And by doing so, you will have access to the tremendous benefits attributable to membership of the foremost bilateral chamber in Nigeria. Ladies and gentlemen, my job here would not be complete if I do not draw attention of this special audience to our NBCC Plaza project. This is a four-story structure currently being developed at Lekki Phase 1, and the facilities in there will include a business incubator, a British Trade Center, conference rooms, training suites, and administrative support facilities for members and the public. Although significant progress has been made with the support from all our donors, we will require additional funding to ensure the timely completion of the plaza. To help make this a reality, we are launching a special fundraiser tagged Project Hope on Wednesday, 14th of October at 11 a.m. Kindly save the dates in your respective diaries and please create time to try and join us at that event. Mrs. Ayomide Olajide will send our email address to the chat, and you will be able to please confirm whether or not you would like to join us for the launching. Before I end, I would just like to thank all our speakers for today, the Registrar General of the CAC, Mr. Emua, and our partner friend from PwC, and indeed our Deputy President, Mrs. Adeyemi, for creating time to be with us today. I wish you all a very, very rewarding session and do hope that the benefits that will come today will help all of us in reshaping our businesses and particularly enable us to take advantage of all the new initiatives that have been put together by the federal government of Nigeria, particularly as it relates to the ease of doing business. Thank you very much, and I wish you a very, very pleasant session.
Thank you very much, Mr. President, for that warm welcome. Good afternoon, everyone. My name is Bisi Adeyemi, and I warmly welcome you to this afternoon's conversation. CAMA 2020 has become one of the most celebrated pieces of legislation in recent times. Little wonder, seeing that it repealed the 30-year-old Companies and Allied Matters Act 1990. The new Act has 870 sections compared to the 613 sections of the repealed Act. It remarkably introduces a lot of novel provisions, including single shareholder companies, electronic filings, signatures, share transfers, and virtual meetings, amongst others. To discuss the various reforms and the implications of this to the ease of doing business in Nigeria, I'm joined this afternoon by a distinguished panel of subject matter experts that had earlier been introduced by the president. But just so that they would now be formally introduced, and if they can please turn on their cameras as I introduce them. Mr. Theophilus Emua, Managing Partner, Elex. Alhaji Garba Abubakar, Registrar General, Corporate Affairs Commission. Mr. Taiwo Oyedele, Fiscal Policy Partner and West Africa Tax Leader, PricewaterhouseCoopers. Is also known as Mr. Tax by some people. Okay, before we go into the discussion, which, like I said, I'm sure is going to be very exciting and very interesting, we'd like to take a poll just to get a sense of what our audience this afternoon know or think about the new CAMA, and to sort of set the tone for this afternoon's discussion. So Secretariat, if you're ready, could you please launch the poll? I will encourage you all to please participate. The first question wants to know if you have taken time to read through the new CAMA, either because you have read it in full or in part, you have read a summary by way of a newsletter, you have attended a webinar, none of the above. Please start to vote now. The second question is, which of these reforms under CAMA 2020 would you consider to be the most favorable to your organization? Reduction of filing fees, a single member company, virtual board and annual general meetings for private companies, limited liability partnerships, electronic signatures, the exemption of private companies from having auditors or company secretaries. And the third question, CAMA 2020 contains some corporate governance provisions. Do you think corporate governance should be legislated? Yes or no? Which of the following best describes your opinion of the new CAMA? It mirrors good corporate governance and best practice. It clears regulatory hurdles. It fosters investment and promotes ease of doing business. All of the above, none of the above, or I am not sure. Please start to vote. We will end the vote in a few minutes. As soon as we have a significant number, we'll end the poll. We'll give just one more minute and we will end it shortly. Okay. Secretariat, can you end the poll? I think we have a sufficient number. Can we have the results up? Okay. So, well, everybody, I mean, the majority of us, 45% have read either a summary or a newsletter. 10% have read the Act. The RG will let us know if that version that they read is the authentic one. Which of these reforms under CAMA would you consider to be the most favorable? And the single member company and electronic signatures have it. So the 23% to both. Okay, and not unexpected. Contains corporate governance provisions. Do you think corporate governance should be legislated? I'm surprised. 88% think that corporate governance should be legislated. I'm sure Mr. Mua will find that interesting and we'll have a conversation around that. Which of the following best describes the opinion of CAMA 2020? It clears regulatory hurdles. I think that 37%, all of the above, and 20% are not sure. Okay, Thank you very much, everyone, for responding and for giving us the benefit of your thoughts on the CAMA. So I'll start with you, Mr. Mua. If you would please just give us your own take on what's the impact of CAMA, particularly on small, medium, and small size organizations. What's the direct impact to them in your view?
Thank you very much, Mrs. Adeyemi. Well, CAMA has made operating a company at the CAC much easier. That is, the new CAMA has made it much easier for small companies. They don't have to have auditors, they don't have to have secretaries, which was a requirement which many of them didn't actually comply with. That is the truth, you know. So this has removed that burden, so they don't have to worry about being in contravention of the law, of the regulations. It has also introduced single shareholder and single director companies. Again, for many small companies, that was all they were looking for. I mean, they had migrated from having what you would call a business name, and they now transitioned to having a limited liability company, but it was still the sole proprietor that was setting it up. And under the old CAMA, he had to have a second shareholder, and quite often they had to go looking for either a spouse or a relation or a child in order to make up those numbers. But that second person may hold only one share out of 1 million, but it was a matter of complying with the law as it then was. Now they again don't have to have that burden of looking for another shareholder. So you can have a sole proprietor who moves from a business name into a limited liability company and doesn't have to change very much. You know, so those are things which have made it easier for them. But you know, on the other hand,
let me quickly jump in, Mr. Moore. Let me quickly jump in.
Okay, go on.
I have some follow-up questions to that. You know, so yes, whilst you know, some people would say it's a good thing to say I don't have to have an auditor, and it's a good thing I don't have to have a company secretary. But let's look at it from the corporate governance perspective. You know, how much comfort would you have, you know, in a company, first of all, a single shareholder company, a single director company, the person is not accountable to anyone other than themselves. And then to top it up, the person doesn't have a company secretary who sort of helps to guide appropriate governance. And finally, doesn't even need to have an auditor, because you're saying that they don't even need to have their books audited. So from a corporate governance perspective, is this appropriate in your view?
Yeah. Well, I agree with you that perhaps, you know, it has become too liberal. But I was giving you the background that this is somebody who had a business name and operated with that business name with all these things you have mentioned. He didn't have to have an auditor, he didn't have to have, but he had a bank account, he did business, he bought and sold. Some of those businesses are sizable, they're not small. If you go to the marketplace, Alaba Market, wherever, those people have, you know, operate under business names, but their turnovers can compare with that of, you know, so-called established companies. Now we're saying to them, okay, come into this place so that we can have a better picture of what you're doing. Because where he was before, you couldn't really tell what they were doing. So yes, we haven't transitioned, you know, that entity all the way into the proper where we would ideally like them to be, but we have moved in the right direction. You see, now you can say, oh, they must all transition, whether they like it or not. Now, the truth of the matter is that even those who had set up limited liability companies were not complying, and that is the truth. It is only when they needed to do something and somebody says, oh, who is your company secretary? They'll just get somebody to sign the piece of paper. You know, but after that, they didn't talk to the company secretary in default. That is the truth. That's the reality. And I'm sure the RG will have a few things to say about that. But the truth is, out of the 1.5 million companies in existence, you'd be surprised what percentage are actually complying with all these provisions that you speak of. So yes, it's good to have corporate governance and all those things. But the reality is that it is difficult for many of them to do so.
Comply.
Yes.
Absolutely. Thank you. Thank you very much, Mr. Moore. I'll quickly jump to you, Mr. Oyedele. In your own view, you know, again, asking the same question, but in your own perspective, where do you see the biggest impact that CAMA 2020 would have on business in Nigeria from ease of doing business perspective?
Yeah, thank you very much for that question. I think, a number of the provisions are extremely very positive for ease of doing business. But I'll say maybe to make a list, formalization of businesses is going to have a big impact. We have a large percentage of informal sector. And one of the reasons why many of them would not consider formalizing their businesses is because of the hurdles around CAMA. And in addition to that, of course, I know there are tax issues, but CAMA has been a major difficulty. You have to go and look for another shareholder, find another director. And whereas you can just start your business as, Taiwo Enterprises and you don't need anybody's permission. So that is a big one. The flexibility around registering and running a company is also a good one that I think will have a big impact, because what that means is you can easily set up a business. And not only that, the way you run the business is also now a lot easier, particularly with the use of technology being allowed. And also you find that even, thinking about the life cycle of a business, even at exit, whether you're talking about insolvency or rescue provisions, those will have some impact. And finally, I would say is around corporate governance and transparency. So we have a lot more of that now in the new CAMA than what we used to have before.
Thank you, thank you. I'll quickly take you up on the issue of corporate governance. So we see that 88% of the audience think that it's a good thing to legislate corporate governance. But how do you now then put that side by side with the Code of Corporate Governance? We have the National Code of Corporate Governance, and it will appear that at least one or two of the provisions of CAMA that relate to corporate governance, that's with respect to independent directors, seems to sort of conflict with that code. And that's probably why some people are of the view that, legislation should leave corporate governance matters, because this evolve over time.
I was also a little bit, maybe people think that a corporate governance should be legislated. I don't think so. But I would also not say that the CAMA is conflicting with the Code of Corporate Governance. Maybe you can have one or two areas. I'll say it is complementary. So the way it is, a lot of transparency is in the new CAMA. And what if you have transparency that is required by law, it then compels you to do the right thing. Just publishing your accounts and making it available online on your website is good for corporate governance because you're more transparent. So the way I would like to look at this is that the new CAMA is complementary to the Code of Corporate Governance. Maybe we should not legislate things that are very prescriptive, because that way the law is not very dynamic. We know this one took us 30 years, whereas a code, you can review it quickly as things evolve. But I would also be optimistic to say maybe this is now a new dispensation when we start looking at things a little bit more frequently, so that it's dynamic and we don't wait for another 30 years.
Absolutely, absolutely. Thank you. And that I guess, is a concern of those who say you shouldn't legislate something that could evolve over time if you're going to take so many years to review the legislation. Thank you, Mr. Edele. I'll go to you, RJ, as you will know.
Mr. Adeyemi, if I could just come in, just jump in. One quick point.
Yeah. Yes, please.
Now, I suppose another way they could have done it is to say that those corporate governance rules will be subsidiary legislation, and so it could be up to the minister or the CAC to make rules as they go along. I know that in this case, they put a number and said 3 independent, and by the time you have 3 independent directors, you still have to have executive directors, and that means you have a board which starts becoming a bit expensive to run.
Unwieldy, a bit unwieldy.
Yes.
Absolutely.
Yeah.
Thank you. Thank you for that intervention.
Yes. So maybe that's where they got it wrong. They could have put it as subsidiary legislation. Yeah.
Absolutely. Not in the act itself, but again, we're hoping some magic would happen, and I come to the RG in this regard. Can you tell us, Alhaji Abubakar, what's the philosophy behind the amendments to CAMA. Can you just sort of take us through what was the thinking behind? Yes, thank you very much.
Thank you very much, BC. There were actually three key objectives. One is to entrench the various initiatives of the federal government on the ease of doing business. Two, to provide for greater disclosure and accountability by registered entities. And lastly, to strengthen this regulatory power and supervisory powers of the Commission. So these were the three key issues that informed most of the changes in this law. Hello?
Have we lost her?
Thank you very much. I had a bit of network.
Yes.
Connectivity issues.
But did you get what I said?
Yes, I did. Thank you very much. That was very clear. I'll just have a follow-up question to that. How does the CAC intend to work with other regulators? You know, I've mentioned, for instance, the bit about the corporate governance, the FRC. There are other regulators, obviously, that have a stake in ease of doing business in Nigeria. Is the CAC geared to work with all of these other regulators to implement the new provisions of CAMA?
Very well. Incidentally, CAC is a member of the Financial Services Regulation Coordinating Committee that comprises of the Central Bank. The committee is chaired by the CBN and is a committee established by the CBN Act, actually. You have the Pension Commission, you have the Securities and Exchange Commission, you have the Nigerian Deposit Insurance Commission as a member, you have the Nigerian Stock Exchange as an observer, and the Federal Inland Revenue Service. All these are regulators that come under the auspices of the Financial Services Regulation Coordinating Committee. Secondly, we sit on the board of the FRS. We have close collaboration with the Federal Inland Revenue Service. And for some time now, CAC has been one agency that has actually made its database available to virtually all agencies of government at no cost. We provide information gratis to all regulatory agencies, all law enforcement agencies, and even foreign embassies in Nigeria. So Financial Reporting Council, we have a board member, we have a member on the board of the Financial Reporting Council. And incidentally, I was also a member of the National Steering Committee on the current Code of Corporate Governance that was actually approved by the Honorable Minister, which is being implemented now. So moving forward, the work on CAMA preceded the current National Code of Corporate Governance. So most of the provisions you see in CAMA were thought of before even this court came into effect, even before the work on the court started. We didn't want to go back to the drawing board because that would have delayed the legislative process. So we just allowed it to go. What our own perspective is, whatever you have in CAMA will be minimum standard. It doesn't stop sector regulators from issuing their own guidelines and checklists that may even be more stringent than the provisions you have under CAMA. So this will be our approach. We'll engage as much as possible. And to actually implement this law, you require a robust technology.
Absolutely.
That will allow companies to do their transactions remotely without visiting CAC. And for other regulatory bodies, that will allow them access to the information being maintained by CAC without having to write to CAC. So we are working assiduously to achieve this. So this is actually our focus, and we intend to do that as quickly as possible.
Thank you very much, RG. I think a burning question, at least in my own mind, and I think in the minds of our listeners and the audience this afternoon, is that there are a few versions of the CAMA 2020 in circulation. People have pointed to different versions. Some people say they've seen the signed version. Some people say the version that they have has the president's signature and all of that. I think the question is, when are we going to start to implement this act? And would there be a transition period for companies to comply?
Okay, thank you. Yes, the implementation will start as soon as we have the gazetted copy. Unfortunately, the responsibility for the gazetting is not vested in the CAC. It's the responsibility of the clerk to the National Assembly. And I'm aware, only yesterday I made contact. I'm aware that they have already started the process at the federal government press. The first draft was done. They have done their review because they have to cross-check, and they have transmitted the approved version to the federal government press for them to confirm and start the printing. So initially we thought we could start full implementation by 1st October, but you can implement when the law has not been gazetted.
Mm-hmm.
So we are hoping this will be done as quickly as possible. If anybody has any copy of CAMA, I think don't trust the copy you have, because usually the president's signature is always at the last page.
Mm.
You may have a copy that was in circulation in 2018 before it was represented to the National Assembly in 2020 for approval. So the authentic version was the version represented as executive bill and approved by the 9th Assembly. So any other copy anybody is carrying may not be an authentic copy. So don't trust what you have. Wait until you have the gazetted copy. In any case, we've not started implementing this law. There are some provisions that will have transition period, like issues about multiple directorships, issues about even independent directors. You can ask companies to start complying immediately. There are matters that will require the approval of the general meeting. You don't just call general meeting just because of that. So CAC will not begin to insist that certain things must be done immediately. But by the approval, by the assent, the law is supposed to take effect immediately. There's actually no transition. It's supposed to take effect immediately on the date it was assented to. But by the Authentication Act, you can't just start implementing a law that is not gazetted. So we are waiting for the gazetting to be done. A lot of things will start when we have, apart from the transition provisions, you also need the electronic medium to do some of these transactions.
Absolutely.
For existing entities, it will be very easy. We'll be able to tweak the existing application for companies and other applicants to do their transactions under the new legal arrangement. But for the new legal entities like limited partnerships and limited liability partnerships, this will require a whole new application or a change request on the existing application that may take some time to develop. So that may not be available until the end of the year or early January. But for other aspects, like the issue of one-man company, issue of issued share capital, other disclosure requirements in the law, the issues of disclosure of persons with significant control, most of these things will be available as soon as the law is gazetted, because we are working on our software at present. We are modifying it to suit some of these provisions. So as I've said, don't trust any version until you have the gazetted copy, because we are informed that there was even a fake gazetted copy in circulation.
Oh dear.
The law has not been gazetted yet. So if anybody is circulating any copy, that is actually fake. Thank you.
Okay, thank you. That's comforting to note. You've answered the second question I was going to ask, but I would ask it all the same. So there are some concerns around implementation. Particularly when we're talking about electronic signatures and the implications of that, filing returns electronically. Is the CAC ready in terms of technology, the infrastructure that will support some of this innovation? Is the CAC ready? And do you envisage any challenges with implementation from your own perspective, from the CAC's perspective?
Okay, thank you so much. As you know, CAC is one of the few organizations in Nigeria that has electronic systems that allows you to do your transactions, pay online, upload your documents electronically, even though you may not get the results electronically because you are still required to pick your certificate in any of our designated offices. The post-registration model that will allow you to make changes has not been deployed. So we took the advantage now to build an end-to-end solution that will allow you to register. We will not be sending physical documents again to any customer. We'll issue you certified copies that has a QR code. We'll issue you certificates that have QR code. with our CTC stamps. And moving forward, some of the strict requirements that you must even have signatures on documents may not be necessary. The way the system we are going to deploy is designed is to allow you for every company to have an account, electronic account. We'll give them username and password. With that, they will be able to make their changes. We are not going to dispense with accredited customers, but we'll validate the accreditation by aligning what we have with the NBA database of legal practitioners and the database of other professional bodies that will allow us to know your enrollment number as a professional, and we'll validate your information before we give you any accreditation card. So even now, the infrastructure is not hosted in CAC. We are hosting all our facilities in a tier 3 data center under a managed service arrangement with a commitment for 99% service uptime. The challenge we had then was, or even now, we don't have any existing disaster recovery system that will allow you to switch over to a redundant site when you have issues with the primary site. We are working towards that. By the time we're going to deploy the new system, we'll have a redundant site where if the primary site has any issue, within a matter of minutes or seconds, you switch over to redundant site and you won't suffer any loss of data. So we are working assiduously to achieve this. And most of the way, we are going to change a lot of things in the way and manner we transact with CAC. Moving forward, lawyers will be allowed to file, but companies will also have their accounts. They may create their lawyer. They may create any of their officers. We'll have authentication system, and we'll have a system where majority of the directors will present a person, a designated or authorized signatory that will be allowed to sign any document on behalf of the company. And by this document, by signing, it may not necessarily even be a physical signature. Once somebody logs in using that account and submit documents through that account, that information is deemed to have come from an authorized source. And also moving forward, because of concerns about data privacy, we may likely dispense with the system now where certified copies of documents are issued to third parties with signatures and sometimes passport numbers or national ID numbers of directors and shareholders. We are going to dispense with that. We'll be issuing extracts, certified extracts from our register that will tell you who these directors are, because even the new law has provided for restriction of certain personal information by director that allows a director to apply to restrict his residential address. So moving forward, we are going to bring this into the new application where such information is restricted. The information that will be in the public register will not contain the restricted information. And to enforce privacy law and regulations, we may not be issuing any document that has personal information like signatures and passport numbers. Yes, telephone numbers and passport numbers of the directors or shareholders. So, in fact, we are targeting that this system should be in place by the end of this month, hopefully, or latest by first week of November, because we have done considerable work on this. And we want to see if we can deploy this. We'll launch it together with the implementation of the new law so that people can go to sleep. Thank you.
Oh, we wish you all the best with that, Saraj. I'm going to come back to you. But before we throw open the webinar to questions, I'm going to go to Mr. Taiwo, Mr. Oyedele, with respect to a particularly controversial section of the Act to which he has reacted. I'm going to read to you something that you said. I'm talking about section 839, the one that deals with trust, not for profit organizations. So this is you, Mr. Oyedele. Not-for-profit organizations, including religious bodies, are registered on earth, not in heaven, so must be willing to comply with the rules and regulations by relevant authorities, just like any other organization. All entities registered under CAMA are subject to regulation, so I do not think that NGOs should be different. I would like you to speak on that part of CAMA that says that the CAC has a right to remove erring trustees. Mr. Idele.
All right, thank you very much for that. And I just did that my comment about they're registered on earth, so not in heaven. I think if we stand of that provision in the new CAMA, it's all around governance, it's around transparency, it's around ensuring that public interest is protected. Bear in mind that NGOs, churches, more.
And so I think there's some interference. Your network might be a bit unstable. Okay, I think he dropped off the call. So we'll quickly go to the Q&A. I see that there are quite a few questions in the Q&A box, and not unexpectedly, RJ, I'm sure you're ready for us. Most of the questions are yours. So the first one, the new provisions on single member partnership, does it eliminate the business name vehicle?
No, the provision, there is no single member partnership. It's either you have limited partnership or limited liability partnership.
Sorry, RJ, I think that person would have been talking about single member companies.
Company. No, yes. No, it doesn't eliminate business name. The distinction between companies and business names still stands.
Absolutely.
A single member company has separate legal personality from the member. It has perpetual succession. So even where the owner dies, somebody can continue with the company. It can sue and be sued in its own name. It can own property in its own name. These are not available for a business name. So it's still a company. But let me seize this opportunity to correct an impression. The fact that you have a single member company, if that company does not qualify as a small company, that company must have 2 directors. So where the turnover threshold or net asset threshold of that company, or where that company has foreign participation or government participation, even with a single member, that company must have minimum of 2 directors. So I think we need to take note of that as well for single member.
Absolutely. Thank you for that clarification. This question is also for you, but I would also like Mr. Mua's views on it as well. What is the CAC doing about having an equivalent of the UK Companies House, where you can easily access information about a company, ranging from directorships to charges without any human intervention? This will make it easier for due diligence checks by investors.
Yes, it's part of what I actually said. This is part of what I have just mentioned. UK Companies House started from a certain point, and we intend to do that. The challenge we have with the current database is, over time, the database was not being updated. You have information about directors. It doesn't tell you when somebody became a director or when he ceases to be a director. Some of the fields, like charges and other things, because those processes were processed manually, there was no corresponding update on the database. So what we intend to do with the new system is, it will cover the whole gamut of our processes that covers the life of the company, from registration to dissolution. And all what happens in between, the filings will be made electronically, and the information can be accessed by everybody. But moving forward, we'll only focus on active companies. We'll only update the records of active companies in order not to get overwhelmed. We have about 4 million entities in our database because we want to start building this data from the scratch. The only information we are going to move to the new application may just be the name, the date of registration, and the registration number. So every other thing, we'll build it afresh, and we'll give opportunity to companies to update their own records with the CAC. We'll create an interface for them to submit this information. We'll validate from the physical records and confirm and update the database. So this is actually our target. Even now, you can still get some of this information free. It may not be at the level of the company's house, but as of today, if you want to know whether a company is registered in Nigeria, with our public search, with the public search window on our website, you'll be able to know the name, the address, the date of registration, and the registration number. That was a deliberate policy. We may not be able to give all information free of charge. You may still be able to view the information for 1,000 Naira. You can view everything, but you cannot download. Even if you download, we'll put a watermark on it so everybody will know that. Yes. But if you need certified true copies, you can obtain certified true copies electronically. This is actually what we intend to do. And as I've said, our target is the new system should be in place by the end of this month, or latest by the first week of November.
Thank you. Thank you. Mr. Mua, do you want to sort of respond to that from a practitioner's perspective?
I mean, what the RG has said is correct. I mean, right now you can do basic searches to check if a company exists or not. But to get more detailed information, you have to go to apply to the CAC for a search. But I believe they are working towards making more information available. So I guess it's a matter of time. And COVID has, how should I put it, inadvertently speeded up that process because of COVID, people could not travel as easily as they did before. In fact, CAC has now stopped allowing people to come in physically into their premises. So you have to write and get a reply from CAC. So eventually they will be able to do it more quickly if they do it online, where you can, with your account, go in, extract the information you want, and do what you need to do. So I think they're moving in the right direction. I hope they get there as quickly as possible because practitioners are indeed suffering a little bit because of the delays. But I applaud them.
Thank you. Thank you very much for the vote of confidence. RG, somebody here says, I mean, I don't want you to respond, but just for your information, that the watermark can be removed. I don't know how.
Well, let him pay for CTC. When he pays for CTC, we'll remove the watermark.
But it says the watermark, maybe they have a way that they do it, but it says the watermark can be removed, so maybe you just want to check and be sure that that security is foolproof. So there's a question here, and I wouldn't say that I don't have this concern as well. The object clause, that the restriction on the object clause to do any business, what will be the revenue of the company since there is no ordinary course of business? I mean, well, maybe put the other way. My own concern with that, the fact that you're not restricted to a particular object. What comfort will that give a lender, for instance? So, and I'm asking this of Mr. Mua, and maybe Mr. Oyedele also wants to chip in. A finance house, I mean, just to use that example, or let me even say, the fashion business, and then, because of COVID or some other thing happened, and I suddenly start to do another business. Meanwhile, I have a facility from a bank, that was given to me because they had done due diligence, and that's what I'm doing. And now suddenly I can do anything because under the new CAMA, I'm not restricted to the objects in my memorandum. What's your view in this regard? Is that something that would give comfort from the perspective of a lender?
Well, I agree with you that there is indeed a problem with those provisions. There's in fact a conflict between a number of provisions. On the one hand, you are told that the company can have do anything it wants. On the other hand, there's still a requirement that the company must file a memorandum of association. So I think there's some cleaning up that needs to be done. If you look at between sections 27, 35, and 43, if you look at those three, one requires you to still have a memorandum of association that states the nature of your business. Another one says, oh, a company can do whatever it wants. So there's some, conflict between those three provisions. I think, CAC and the draftsman they need to decide what they are trying to achieve. To say that a company can do whatever it wants, unless there used to be a provision in the old act which said you had all the powers of a natural person, which was not that, it did not mean that you could do any type of business, but it meant that the actions you could take, to enter into a contract, the way you enter into a contract could be done the same way as a natural person. But now they've amended it, and it seems to appear to have expanded it. But I suspect perhaps what they had wanted to achieve was what was in the previous law, which is that in terms of execution of your business, you could have the powers of a natural person. So I think that cleaning up needs to be done. Yeah, I think there's there's been some error in there. I don't think that it was intended this way. Otherwise, you would not need 27. But I think they're trying.
Let's hear the RG. Let's see whether the RG has a perspective.
Okay, thank you so much. As Mr. Emo said, even the positioning of that provision was actually wrong, because it referred to the articles when objects are actually supposed to be in the memorandum. For us as a regulator, I think we'll overlook that provision and go by the sections that says you must have the objects in the memo. And even where that is not going to be overlooked, we are aware that there are certain sectors that you have to limit your objects. You can't go and operate a bank with unrestricted objects. CBN will not allow you. So we have to be mindful of the concerns of other sectoral regulators. And the best way to address this is we allow companies to pile their objects, and you operate in line with the provision that says submit your memorandum and the objects. Because the same provision, the same law still has provision for alteration of objects. So if the intention was to make objects unrestricted, so you wouldn't have such provisions.
Absolutely.
So that was an incongruity that will be addressed maybe in subsequent amendment of the law. Thank you.
Absolutely.
Yeah, let me just add my own little comment. Sorry, my internet is not very stable. I think that the underlying principle is flexibility. So if I run my enterprise today or partnership, I can decide to do something else. COVID has stopped one business. I see opportunity elsewhere. I'll quickly adapt. And we should not use the law to come in the way of that flexibility. I do have that, including for less money for any business, that they said, so it doesn't make the risk go away. What we need to do is think about safeguards, so that while we're allowing the flexibility, we don't create too much risk for the system.
Thank you. So I'm going to stay with you. The question that you were answering before your internet went off, because there's a question here in the box, related to that. The removal of an erring trustee under Section 9 of the Act as amended will it be solely done by the Commission or upon an application by a member of the public or the organization involved? I guess that's that question the RG would answer. Secondly, how does the Commission determine an erring trustee? I would just like you to complete what you were saying earlier on before I leave the RG to answer the bit about the role that the Commission will play in that actual removal. Mr. Idele. Okay, I think his network is back at it. So RJ, over to you then.
All right, thank you very much. So what I was trying to say is,
we still cannot hear you. So RJ, please.
Okay, thank you. Section 839 subsection 1, in our view, should be read in conjunction with 839 subsection 7, 839 subsection 7, that provides for inquiry. CSC will not just remove a trustee without an inquiry. He is entitled to be heard, and the inquiry may even be carried out under the auspices of the Administrative Proceedings Committee that is established by Section 851 of CAMA. So the law allows anybody to send a petition to CAC. If anybody has reason to believe that a trustee has abused his office or has defrauded the organization or where there is misconduct or mismanagement that will necessitate such inquiry, regardless of where we got the information from. If the information is credible, we'll institute an inquiry to determine whether it's true, and the person is entitled to be heard. You will be entitled to legal representation, because the 851 that provides for the establishment of Administrative Proceedings Committee, although the procedure for the deliberations of the committee are not stated, but it's clear that you are even entitled to legal representation. And if after the inquiry, after the investigation by the committee, after its proceedings, the allegation could not be confirmed, or it may not even lead to that, where preliminary findings shows that the allegation was frivolous based on the response that was provided by the trustee, because usually in such matters, you have to hear from the other person. When you receive such allegations, you have to send a copy to him for him to respond. If after his initial response, there are grounds to proceed with a full inquiry, then you refer the matter to the Administrative Proceedings Committee. And in the course of its deliberations, if the committee now confirms that the allegation was true and the trustee has abused his office, the process of suspension, in our view, cannot be carried out without following the letdown rules on how the decisions of the committee can even be confirmed. Because even after the committee has come up with the decisions, the law says the board of the commission has to approve it. And on ground where it relates to suspension of trustees, the suspension has to be approved by the Honorable Minister of Industry, Trade and Investment. So this is our own position on the matter. And regardless of the source of the information, the trustees will be heard before any further step is taken to either institute an inquiry before his suspension. Yes, thank you.
Thank you. From some of the things that you said, RJ, I mean, I would imagine that, and the Act actually does say so, that there will be regulations to guide the implementation. And I know that you had said in one of the engagements that these regulations were in the process of being finalized. Are you able to, sort of give us an indication as to when to expect?
Yes, we have. What we have done, because you can't bring busy stakeholders to come and sit for 1 week, 2 weeks, working on the regulations. You have to have a working document that they can review. We've done some things in-house, adopting best practice. So management will do a final review. We had an in-house committee. We will now expose it to our stakeholders, like the section on business law, IOD, and other key stakeholders for their comments. Initially, we wanted to have a gathering of all key stakeholders to deliberate on this, but that will only happen after we have gotten the feedback from these stakeholders. So we'll have a small group, not of CAC staff only, but key stakeholders, even some members of the NASBA committee that worked on the first draft of the bill. Will co-opt some of them to look at the draft vis-a-vis the comments that were received from different stakeholders. Then we come up with a harmonized version. Maybe the only thing we may not expose is our schedule of fees, revised schedule of fees, because we may not put that. So that may not be subject to public debate.
We're holding our breath.
But there won't be any material change, actually. Thank you.
Okay. Thank you. Thank you very much. Mr. Yedele, this question is for you. Kindly speak to the contradiction between the small business, as defined by CAMA, and the Finance Act.
Yeah, thank you very much. Hopefully my internet will allow me to make my comments. So on the, the charity or trustees, I think there's lack of trust between government and the people. And what government needs to do is to respond to that by giving the assurances that there will be safeguards. I have no doubt in my mind that the objectives are noble and it's in the interest of everyone because these are public interest entities. So having said that, in terms of the conflict, I think maybe CAMA, the new CAMA is more progressive than the Finance Act. And I'm actually now at a retreat, which is why my internet is not very stable, where we're working on the finance bill for 2020. And one of the things we are discussing is how do we harmonize it? I do think that I prefer the provisions of CAMA, where a small company does not have to worry about external audits. So it just encourages small businesses to do what they have to do and let them progressively adopt corporate governance and also don't increase their cost of doing business unnecessarily. So I don't know whether the threshold will be as high as what we have in CAMA, but I think there's a general agreement that we need to provide some exemptions for small businesses from doing external audits.
Thank you, thank you. So this relates to this. There's a question here as well, where the tax authorities request for the audited financial statements in the course of a tax audit for a company that is considered to be a small business under CAMA, you know, and such entity does not have any, you know, because they are taking advantage of the provision of the new CAMA, will they be penalized?
No. Once you have, you know, the CAMA and the CETA are laws of equal authority. So one is not superior to the other. So if CAMA says you don't need audited accounts, if CETA says you need audited account, then FRS has the right to ask you for audited account. But once CETA is amended to say that you also don't need audited account, then it will be illegal for the tax authority to come to you and say you must provide audited accounts. It is that alignment we are trying to get now so that there's no conflict.
Absolutely. Thank you very much. RG, I'm going to take this last round of questions as we begin to round up. I'll take these two questions together. The first one says, in recent times, the CAC had been very slow in registering companies and issuing RC numbers. It is no longer certain that you can get a company or business name registered between 1 and 2 weeks, like it used to be in the past. Sometimes they tell you there's no paper to print. What is the challenge? And is there anything being done to speed up the process? The second question is, what's the plan to upgrade your branch offices on E-level transactions without having to go to Abuja?
Okay, thank you so much. Yes, before I respond to this, let me comment on Mr. Edele's remarks on the Finance Act. We actually intend to lower the turnover and the net asset threshold in CAMA because the law has given the minister the right to issue regulations. So we may likely align the turnover with what obtains in the Finance Act, where you have 25 million turnover, because 120 million is very significant for a small company. Then on the issue of delays, you see, we tend to forget that we are still under a pandemic. And as a government organization, we are still restricted to only level 12 officers and above. In the past, before the pandemic, our offices in Abuja and Lagos, we run 2 shifts just to be able to deliver. We have the first stream, they come and close by 2. The second stream start by 1 and leave by 7. With the pandemic, that's not possible. The total number of staff, let me take the head office in particular. We have 750 staff in the head office, including staff that work in support departments like admin, human resources, and other departments that are not in the core operations. Of this number, less than half are actually on level 12 and above. So, and the irony to all this is the volume of application has increased tremendously, even with the COVID. In fact, we are recording almost twice the volume that we used to have before the pandemic, with very few staff to attend to these applications. That informed our decision to suspend the physical presence of customers in our premises. We now introduce the mailing system because the few staff that are around, if they have to attend to customers on day-to-day, because in Abuja in particular, we used to have minimum of 600 people visiting our office in a typical day. So you can imagine before the ease into even level 12, initially it was level 14 and above. We had about 150 staff out of 750. And it was becoming overwhelming. So, and at that time, it used to take more than a month to even collect a certificate after it is printed and sealed. So when we introduced the mailing system, as of today, all certificates printed in the head office, we publish the list on our website with the name of courier companies that you are going that will deliver it to you, or you can pick it from. And the other time we had to call these courier companies because there were complaints that when they received these certificates or these documents, sometimes they may not even call the customer until after a week or 2 weeks. We've entered into agreement with them that they must contact the customer within 24 hours. The customer has a choice, either to pick it from their office for a fee of 500 naira, or they deliver it to his address. Where we have other challenges are post-incorporation filings. In the past, customers were allowed to come and present these documents to be verified, and they get their results. Most of the vociferous ones had connect within the system. That's what we discovered. They had people within the system that facilitate this transaction for them. So now that there is level playing field, they couldn't prioritize again. They have to queue like every other person. Some of them are complaining. But only last week, we have published our revised service timelines for Abuja, and we have committed to registration, new registration within 48 hours. This is working. From uploading of your documents, if your application has no query, we'll give you certificate within 48 hours, even with all the challenges. And for post-incorporation services that are normally done manually, because you have to send this application through a courier company, most of them will have committed to 5 working days. For most of the other offices like Lagos, the challenge we have is we had backlog of applications, right from the time the total easing of the lockdown. So you have very few staff in the office, and the number of applications has tremendously increased. So staff have been coming to the office on weekends, Saturday, Sunday, just to be able to meet up. Because what I used to tell some of our colleagues is most of the law firms still work from their homes. And some of them want to visit CAC when they are working from their home. Most of their offices have been closed, but they want to come to CAC to do transactions. So is it that we don't have lives? We have a responsibility also to safeguard the lives of our staff. So most of these measures, as I have said, are interim measures. Yeah. Our target is to have an end-to-end electronic solution where you can, from anywhere, you can do a transaction with CAC. But the mailing system and the email system are working because, as I have said, we had a lot of backlog, but most of this backlog have been cleared. We are now treating applications as they are submitted. Even such requests, a customer has the option, we can send it to you by email. If you want your search report by email, we'll send it to you. It's faster. If you want it to be sent through a designated courier company, we send it to you. So we have eased a lot of things for customers. But we just need to be patient. But particularly for Abuja, some of them, when they wake up in the morning, they don't have anywhere to go except CAC. They begin their day in CAC and they end their day in CAC. So now we have knocked our doors. People are complaining, but we are encouraging a lot of them. Go and join together, go and pull some resources together and rent an office so that you will have an address that these documents can be delivered to.
Thank you very much, RG. And I have to agree with Mr. Mua that indeed, CAC has lived up to, taking up the challenge that COVID, posed in a most encouraging manner. We have to round up now. Fortunately, we still have questions in the Q&A, but again, time is never our friend when we're doing something like this, but I'm sure there will be an opportunity later on to come back and answer some of these questions. So in closing, I'll just like each one of you, gentlemen, to please share your one-liner, 1 or 2 lines, what you consider to be the key opportunities, and if there's a reservation that you have, as a challenge, with the implementation of the new CAMA. I'll start with you, Mr. Oyedele.
Thank you very much. I think I'll say generally it's a very good piece of legislation, but it's not perfect. One good lesson is that this was a collaboration between the private sector and the public sector to make it possible. One of the areas that I would have loved to see an improvement is allowing companies, even for force people to incorporate companies. We just need them to net easily. UBA, for example, has a branch in New York, And then we shouldn't wait for another 30 years to do the next review. You cannot make a good meal without good ingredients, but having good ingredients is not a guarantee that you make a good meal. So how we implement this is very important. I think we can do it collaboratively. Thank you.
Thank you very much. Mr. Moa. Mr. Moa, I think that connectivity issues. Okay. So RG, in the meantime, can we hear from you?
Okay, thank you. I just want to seize this opportunity to assure our customers and the investing public that CAC will provide the technological solution that will allow them to do their transaction with the CAC end-to-end without having to visit CAC. And as the agency responsible for implementing this law, we will be objective, we'll be responsible, we'll be strict, but we'll also be flexible. And we don't know it all. We'll engage our key stakeholders moving forward in all our subsequent actions, both in implementing, interpreting, and enforcing these laws. So as I have said, you can't achieve anything without technology in our today's world. And we have recognized that. We are building a technological solution that will resolve most of the current challenges we are facing. So they should just be patient. All the hiccups and challenges being encountered, even now, a lot of effort has gone into resolving most of them. And by the time we deploy this new system, from anywhere in the world, you can do your transactions with CAC remotely, you pay for your transactions, and you get your results electronically. Thank you so much.
Thank you very much, RG. So to just sort of round off what you said, and I think that will be the key takeaway for our participants this afternoon. Collaboration, like Mr. Oyedele said, it's going to be a joint effort between the private and the public sector, working hand in hand with CAC and the other regulators that have to see that CAMA 2020 is implemented as intended. CAC is going to be objective, as the RG has assured us, is going to be responsible. For me, most important of all is that it's going to be flexible. These are uncharted times. Nobody has walked this path before. I mean, see what happened with COVID, but we've all been able to sort of adapt. So I think it's important that flexibility is key. It's been a wonderful session, but before I give my final vote of thanks, we have a few announcements. Since I still have the audience with us before we begin to lose everyone, I'll just quickly like to run through a few announcements. The president already shared with you the fact that we are building the NBCC Plaza, and we will be calling on you, our very esteemed audience, to join us in what we have termed the Project Hope, which will be formally launching the fundraiser for our plaza next week, Wednesday, the 14th of October. Please look out for invitations to that event. It's going to be an evening of entertainment. With respect to upcoming events, we have a few upcoming events that the Secretariat would be sending out details of them as we go along. The first one is a webinar on Nigeria's communication industry post-COVID, and the other one is our flagship EduTech. It's an educational conference that will be happening on the on the 23rd of October. So would again ask you to look out for the details so that you can register and take part in the conference. It's usually a very interesting conference, and this year, for the first time, of course, because of COVID, we'll be having it virtually. So on behalf of the President and Chairman of Council, Mr. Kayode Falowo, members of the Professional Services Group, and the Executive Committee of the NBCC. I would like to very sincerely thank our distinguished panelists. You've been very wonderful. You've taken out of your very busy schedules to join us this afternoon and to provide such valuable insights to CAMA 2020. I would like to thank Alex for collaborating with us in this regard, and for our ever efficient secretariat. I also say thank you and kudos for delivering yet another successful webinar. I thank our very engaging audience. You have been indeed very engaging. Your questions have been thought-provoking, and we look forward to seeing you on Wednesday and at our future events going forward. Thank you very much, and do have a good afternoon, everyone. Thank you.